The general.
Colleagues, good morning. I think it's been one of the shortest days in court so far. We have some remarks to share with you. I want to start by quoting about 3 or 4 things that the Supreme Court of the Republic of Ghana, speaking through His Lordship the Chief Justice, put out today. First is that the law is settled, that a party cannot be compelled to adduce evidence under the circumstances that we are discussing. The law is settled on that matter. And you notice that the Supreme Court spent some time to educate all of us who are interested in the legal profession or are following this case on the various cases in times past when the courts have ruled, sometimes up to the Supreme Court, that that is the position of the law. Nyamiche versus Ansa, Bamo and Labi, Te and another, AMA and Hydrofoam Estate Society of Lawyers, they went at length to remind all of us that on several occasions the courts have had to lay down this rule and that the law is settled. So if anybody comes with some new arguments as though it is a gray area of the law or that it is possible to compel a party to come and adduce evidence in circumstances like this, the law is settled that that cannot happen. The second point that the Supreme Court has made, which I think is very important for us, is that a case is won on the strength of the plaintiff's case and not necessarily on the weakness of the defendant's case. A case is won on the strength of the plaintiff's case and not necessarily, even if so, on the weakness of the defendant's case. So this suggestion that the defendant, or in this case the respondents, must mount the witness box to enable the petitioner complete or strengthen or make a case is contrary to what the law and the practice has been for all of these decades. The third point that the Supreme Court has made today, that it has heard all of these arguments about she holds a constitutional office, the EC is a constitutional creature, and therefore there must be accountability. You remember that even for us speaking to you last week, we said if you want accountability, let's all go to Parliament, whether it's Public Accounts Committee or a parliamentary inquiry or something. But when you come and you apply to the court under some specific rules, you don't fail to meet that standard and then resort to that general argument. The court has said something about it, and I think we need to take note of it. It says that the fact that she holds a constitutional office and that there's a constitutional responsibility involved does not mean that a different set of rules must be made up. And I think it's very significant that the fact that she holds a constitutional office or that there are constitutional responsibility questions that are being raised does not mean that a different set of rules should be made up. So today the question that the court invited us so that it will answer whether or not a party can be compelled to adduce evidence, the court has answered it and has given the many instances in which it has arrived at this similar position. Now you remember that our colleagues on the other side opposed our statement to the court that we were closing our case. And please let me just take you back. They made their case and closed their case. When it was time for first respondent said that first respondent was also closing its case and did not intend to invite anybody to adduce evidence. And that closure took place. Second respondent did same. So all 3 sides have closed their case. That was when they objected that we cannot close our case and they cannot close their case until they bring in the EC chair to be cross-examined. And they opposed on 3 grounds. That they are of the view that she has already elected, or the EC has elected to adduce evidence. And you heard the long submissions that were made. Even our colleagues who came before you tried to make a new case that election happened when the court gave orders for the filing of witness. Today the court has settled that matter, that is not true. The court gave an order that we should file witness statements. We even complied. They did not comply. The court had to give them leave to come and do it a second time. Compliance with those orders does not amount to election to adduce evidence. The court has settled that question. This other argument was made that because of some of the averments in her affidavit, it amounts to evidence in the substantive matter before the court. The court has explained that the affidavit in interrogatories does not amount to evidence. The affidavit at the interlocutory level does not amount to evidence in the substantive matter. And I think it's a major point of law that all of us who are following should now follow. And I think this conversation of constitutional rule and accountability has been dealt with. Now, the Supreme Court has also reminded us of the threshold of what an election petition has to be. You heard the court, speaking through the Chief Justice, refers to the ruling of 2013 that the party petitioning must show that A, not only were there violations, but the said violations affected substantively the result of the election. And that you have to establish this. It is after you have established this that the burden of proof shifts to the other side. And that you stand or you fall on your own case. And then very finally, you notice that the court was at pains to point out that sometimes some of the cases we have been citing are of no moment to the matter before the court. Sumaila Bilbil was raised. The court said it's of no moment in this matter. It has to be distinguished. Remember the last time they cited Elis Tamaklo. The court said it's of no moment to the matter we are discussing. So we think that it is important that some key attention is paid to some of these issues. Right now where we are is this. The petitioner who petitioned the Supreme Court that nobody won the election and that he has 5 witnesses to prove that nobody won the election. He's called 3 of the 5 witnesses and in the end has closed his case. The first respondent said, I don't have any witnesses who I think have to respond to this supposed case. And so I don't intend to adduce evidence. So I close my case. Second respondent has said same and has closed its case. And now the court has given orders for when we should bring our written submissions. Our lawyers have started working on that. We hope to meet the deadline that the court has put out. The petitioner is now informing the court that he intends to come with an application to reopen his case. Of course, that application to reopen the case and cite new evidence comes with its own legal threshold that they have to meet. And that if they are successful at that, then they'll be coming with another application intended to subpoena the Electoral Commission chair. That also has its own legal standards. We find it curious that for a petitioner who claimed to have evidence to make their case and who was not stopped in any way from calling all 5 witnesses, called 3, you saw how the 3 performed, whether or not they addressed the issues before the court, and was not forced by anybody to close his case, was not directed by anybody to close his case, voluntarily announced to the court that, my lords, we close our case is done. We have closed that. We've made enough of the evidence that must be made available to you. So our case is done. Now is telling the court that he wants to reopen his case after the court said you cannot use the first respondent to make your case. And they are even signaling that if they are successful in reopening the case, what do they intend to do? They intend to subpoena the second respondent. Why? To come and make their case for them. Sorry, the first respondent to come and make their case for them. It is becoming clear, particularly to the NDC supporters across the country who have been believing everything they've been saying along the line. First they said they won, then they changed it to they didn't win. In the last 1 week, right before you, they've been changing the argument that it's a constitutional accountability matter. And it's not so much about who got 50%. My learned senior Dominic Ayine has been saying that before you every day. That is a constitutional interrogation that they need to do. And that is it's a constitutional matter. 3 different cases. They keep changing the goalpost. And that is why you heard the court, I think, refer them to the basis on which we're here. So we continue to say that we're in the hands of the court. We will bring in our submissions by the deadline and pray the court to dismiss this petition before it. We'll take your questions.
Okay, so Mr. Minister Designate, I'll ask the first question. My name is Wilberforce Asari. I work with Asasi Radio. When the Supreme Court started its ruling today.
Yeah.
It started by quoting Article 64(1).
Yeah.
And it says that this whole case is about this article.
Yeah.
We've been in court for 14 times, and we've been hearing that this case is about so many things. Why is the Supreme Court saying that this case is essentially about 64(1)?
I will borrow the words of my learned senior Dominic Ayine. I think somebody asked a similar question a few days ago, and then he said this is not a debt collection matter. You recall? This is not a debt collection matter. And that this is not a case between some plaintiff and defendant. It's true, he's right. But what it is that this is a challenge to a presidential election under Article 64(1). And the court has explained what that animal is. That you come before the court and you say, my lord, I'm challenging the validity of person X as having been elected as president-elect and therefore president of the republic. And the Supreme Court has explained what you must meet. The point the court is making is that that is what you came to tell it in the beginning. And therefore, all these proceedings are supposed to be within that confine. They are therefore looking out for the evidence you adduced to make that case. Not this new afterthought argument of accountability, constitutional responsibility that is being made. Accountability, constitutional responsibility is not Article 64(1). It's not, respectfully. Article 64(1) under which they came is to challenge the validity of Nana Addo Dankwa Akufo-Addo having been elected as a president of the republic. But as I mentioned earlier, you notice that they keep changing their position. We won. We didn't win, but nobody won. Now they say it's about constitutional and accountability matters. And to the NDC supporters in particular, your leaders are continuously changing the goalpost and are not meeting the evidence thresholds and standards that they have to meet in. So if the Supreme Court goes back there, we think they are guiding all of us that this is why you people claim you came to court. Let's take within that confines.
Thank you very much. If the action of the petitioner succeeds in court, i.e. leave to subpoena and application to reopen case, would you as second respondent be compelled to also ask for leave to reopen your case?
Well, there are a number of options that are out there depending on the court's rulings as they come. We are of the respectful, humble view that, as the court said today, the principle is that you cannot compel a party under these circumstances to adduce evidence. Even if you prove some fresh evidence and extreme circumstances under which your case should be reopened, and then you come with your second application for subpoena, what is that subpoena supposed to achieve? To compel the person that the court has said cannot be compelled to give evidence. The subpoena is now to compel that person to come and give evidence. We think it will be an interesting set of arguments. But wherever it goes, as we have said, if it becomes necessary that we put witnesses in the box to respond to issues, we are more than happy. I keep telling you that Chairman McMahon comes here every day prepared that if they cross a threshold, then we have to do that. We'll do that. But as you have noticed, unlike the petitioner who, as some of my colleagues have been suggesting, appears to be abandoning the case because he's been here twice, we are always here. If it becomes necessary, we'll be happy to mount the box. But now it's also becoming clear why we filed a submission of no case. Because on the face of the petition, it was, the preliminary legal objection, okay, that this is not an election petition properly so-called. It was clear on the face of the petition. And that is why we put in that application. Perhaps if we had even struggled to go and put in witnesses, we would have been undermining that submission. That submission is still before the court for the court to consider. And so, depending on what the court decides to do, our senior lawyers will take, their next line of action. Indeed, I have heard conversations. I don't know if I have their permission to say this. I've heard conversations by some that if they elect to subpoena the EC chair, maybe we should also elect to subpoena the petitioner to be brought into the box. I don't know if they will agree to it at the end of the day, but it is part of the various, conversations. We'll see how it goes. Yes, sir.
Based on where you have just landed, are you worried by the application coming up? Again, we have indication that there's going to be an application for review on the ruling given today. Is your side worried about the